This is the Limelight, and my name is Prince Apollo. Now, this evening we explore the concept of contempt of court, one of those cases that can be actually slapped on anyone, and basically contempt of court refers to circumstances when a person acts in a way that undermines the court's authority. And this is in regard to events which played out in court this week during the proceedings of the court-martial in a case of retired Colonel Dr. Kiza Besigye, when one of his lawyers, Aaron Kiza, was convicted and sentenced to 9 months in prison for contempt of court. We this evening explore the circumstances that can lead to such a situation, and in the studios we have Kato Tumusime, and Kato Tumusime is a human rights lawyer. He is attached to the Kiza and Company Advocates. Kato, welcome to the program. Quickly, if you can tell us what constitutes contempt of court.
Thank you so much, Apollo, and our viewers here. Now, an offense of contempt of court is actually brought clearly under Article 28, Clause 12 of the Constitution. And that article is clear that any other offenses, for them to be referred to and regarded to as offenses, they must be clearly defined what an offense means. Its punishment must be also clearly brought out in any law that provides for that offense, except the offense of contempt of court. But the Supreme Court has on a number of occasions clarified what amounts to contempt of court, and it has made a clarity between civil contempt and then the criminal contempt of court. So there are two clarifications here. But to say all in all, whether civil or contempt of court, it is an offense. That's one, and an offense that distances itself from the rest of the offenses in regards to what amounts such an offense, which comes at play when somebody conducts himself or herself to undermine the power, the dignity, the authorities in the court.
Okay.
But it only has to be a court of law, an established court, not a tribunal, not a disciplinary committee.
Let's not go there. Let's
but
first
briefly, when somebody conducts himself or herself in a manner that lowers the dignity, that lowers the power, that abuses the power, that undermines the authority in court, then they can be held in contempt of court.
Okay. What I also know about this offense is that it can be inside the courtroom or outside the courtroom.
No. In fact, what the viewers should know is that offense only happens within the session of court.
Sure.
Yes, only. When the proceedings are ongoing, that's when somebody can be in contempt. Because the offense of contempt actually disrupts the proceedings of court. That's when you can be held in contempt. But all these other things that happen outside court and in court before it has started, they cannot amount to an offense of
What about when a person perhaps refuses or does not respect, for instance, the conditions of bail, or what? Can't that also tantamount to contempt of court?
And surely it does not. It does not amount to contempt of court. If you have bond or bail and it has its conditions,
and you do not respect the conditions,
and you do not respect the conditions, and it means you are on default for fulfilling the conditions. But they cannot hold you in contempt for defying. That's why they don't even charge you for contempt of court, because you disobeyed the conditions or terms of bail. But the option they have is to cancel your bail and then rearrest you, but they cannot charge you for contempt. So contempt, for that offense to arise, we must be in court and proceedings must be ongoing. So it must be within a proceeding session. But when we are in court, or the magistrate is not in court and somebody makes noise, that cannot be contempt, because contempt of court in a trial or a criminal manner must happen within the presence and the process of the trial.
Okay.
Yes.
Let us now reflect on the events which played out during the court martial held in Kampala this week.
Yes.
Can the actions of Aaron Kiza amount to contempt of court in one or another?
Now, there is something also that the viewers and the rest of the public must know. That as a lawyer, as an advocate, one, you are an officer of court. And what do we mean by you are an officer of court? You must be somebody knowledgeable to guide court in one way or the other, or to guide the members in that courtroom. So, the ideology of the framers of the Constitution, not to clarify what are the ingredients of contempt of court, I think their vision was beyond the advocates and the lawyers, the officers of court. It is like now a magistrate coming to court and then he finds the clerk in contempt of court, who is an officer of court. Really, basically it does not arise in that manner. But as an officer of court and as a lawyer and an advocate, and if one conducts himself or herself in a manner that undermines the dignity, the power and the authority in court, then we have a disciplinary action that it should be taken against such an advocate. We have law counsel that governs the discipline, the conduct, the behavior, the transaction, the professionalism of the lawyers, not the court itself. What the court does, even we have had so many lawyers being referred to law counsel because they conducted themselves in a manner ordinary that
during proceedings of court.
Yes, in a manner that would ordinarily amount to contempt of court, but because we have a regulatory body, the law counsel, what court does is to refer your matter to law counsel so that you can be dealt with. In fact, it is generally termed as professional misconduct. So basically, most of the lawyers, I have not had any advocate practicing in line of duty representing a client or himself being held in contempt. The only thing that does, even when he acts in a manner that is beyond repair in a proceeding, is to have himself or herself referred to law counsel for disciplinary action. Because we have a body that regulates how we must behave.
Are you suggesting that the case of Aaron Kiza is a rare case?
It is a rare case because if you look at the ruling that the court martial gave, it refers to professional misconduct.
Yes.
And professional misconduct means that the person has behaved outside the scope of in which manner they must have behaved in ordinarily. Therefore, what happens when somebody behaves in a manner that is contrary to what the laws or regulations that govern them presupposes or suggests? You have to refer such a person to the body, the regulatory body, to have him called to order. And that's the process that would have been done. If they used other and alternative words in their wisdom, maybe we could be having a different discussion here. But quoting that the manner in which Aaron Kiza behaved or conducted himself in that court martial amounts to contempt and is an act of gross misconduct, then he should have been referred to law counsel for further disciplinary actions, because the law counsel has always disciplined lawyers who behave contrary to what they are supposed to be behaving under the professionalism of the lawyers and the laws.
So in simple terms, the chairman of the General Court Martial and his bench acted, can you say, in a high-handed manner? They
acted at traverse, they acted out of anger and heat passion that was unjustifiable, but you cannot blame the chairman of the court martial and his tribunal members because they are not lawyers.
Oh.
So they have no knowledge of the law on how they would have conducted that manner, but the blame should actually go to the advocate, the judge advocate, who advises the tribunal members on issues concerning the law, because he would have been clear to them that, look, if a person has acted in a manner that is unprofessionally, unethically recognized and unprofessionally, and therefore is in misconduct, then we should refer this matter, refer this Aaron Kiza to the law counsel that he can undergo a disciplinary action by the regulatory body to call him to order so that he can act in a manner required by the laws and the regulation that govern.
Now, away from Aaron Kiza's case, in other cases where such an offense involves can I say
civilian.
a civilian or an ordinary person.
Yeah.
What other circumstances can constitute contempt of court?
The circumstances, like I have said earlier, include any manner that a judicial officer believes has disrupted the process.
Like yelling in court?
It depends on who is hearing and why they are hearing. One, because hearing, somebody can just hear for no reason. But
like banging the table?
Banging the table, yes, some judicial officers can hold you in contempt of court if you have your phone and it rings loudly and it disrupts the proceedings, then you can be held in contempt of court. If you enter with your shoes and making a lot of noise, if you slap people in court, if you do all those things that can disrupt the proceedings.
Assaulting a judge?
Yes.
Is that contempt, or it goes beyond contempt? It
goes beyond contempt, but the judge can also hold you in contempt and then refer you to the state attorney to prefer the charges of assault and in that manner.
Okay.
Yes.
So it's that delicate.
Yeah, that's how delicate it is.
Even a phone ringing and intentionally it rings while the proceedings of court, I mean within that time when court is sitting, that can amount to contempt of court.
Yes, because you have had people who have ringtones maybe that have dogs barking, and some of the magistrates or the judges or the judicial officers may be fearing dogs. And when such a noise erupts and comes out during the proceedings, it can disrupt everybody.
Okay.
It can maybe scare a witness, scare a judge himself, scare state attorney, any other court user. Then now that's an act of assault. So that's why they usually indicate logos and signs that phones must be off. Because they must say you can keep it in silent. So those are some of the circumstances they are trying to avoid.
In your experience as a lawyer, are these cases, I mean, frequent in a way that, I mean, are those cases? I mean, contempt of court is one offense that is that usually pops up. I mean, in your work, should you anything?
Yeah, surely. It normally pops up. But what the people must know is that even when it is an offense in that manner, that it doesn't show the ingredients that one must prove, or it doesn't show the exact punishment, it is an offense. So for one to be convicted and then sentenced, they must have gone through a trial. In fact, contempt proceedings have numbers. They also give them numbers. It is an independent case on its own, arising from whichever case, but it is an offense. And what happens is that when a magistrate or a judge thinks that you have conducted yourself in a manner that falls within contempt of court, then they charge you. They read for you the charge, they put you in dock, then you plead, and even they give you an opportunity to defend yourself on
which
why.
Was not the case with Aaron.
Yeah, they will ask, why did you conduct yourself in such a manner when you know that it would disrupt the proceedings of court? Then you give your defense. Because the right to fair hearing under Article 28 is clear, and under Article 44 of the Constitution, it is non-derogable. No one at whatever cost, at whatever point, no one can take away that right to a fair hearing. So contempt proceedings, even when the court-martial believed that Aaron conducted himself in a manner that was in contempt, which was not the case, because the allegations say and stick to the previous proceedings that had happened.
He yelled, he banged
he yelled and banged
the tables.
But if you followed the proceedings before Aaron was brutally kidnapped and taken out, we were not in a court session. We were only entering to resume.
It goes back to
our seats. Now,
the fact that it has to be within
the session, because whatever happened did not disrupt any court business, because there was no court business ongoing. Now that people should know that if the chairman court-martial was proceeding with a different case and any other person conducted himself in a manner that would disrupt the proceeding, then that would amount to contempt. But like I said, contempt only arises in courts of law. And in the decision of Amon Vyargava versus the Attorney General, May his soul rest in peace. Justice Kakuru made it clear. I think it's around page 43 or page 44. He said, and referred to the General Court Martial as a disciplinary unit. He said, if you want to give it a good name and baptize it so that people can at least have some belief in it, you can extend it and call it a tribunal. He said it has never been registered anywhere in books that are related to courts of law. So therefore, I said that if anything that would have happened, it would be termed in a different manner, but not contempt of court.
And you earlier on talked about the offense of contempt of court being either civil or criminal.
Yes.
Where is the difference? Just in 3 or 4 minutes.
Now, court gives orders. For example, in a civil matter, they say, Mr. Apollo, you must pay Kato 100 million. That's a court order within a period of 20 days or 30 days. Now, if you fail to fulfill that obligation, or if they say that, for example, Mr. Apple should not host Kato for 20 days here at this program, and you go ahead and host me within that period, then
contempt.
you will have disobeyed the orders of court. Now they will charge you in contempt, civil contempt, because there is a court order already and you have disobeyed that court order. Now criminal contempt happens when we are in a proceeding, like I said, and then you conduct yourself in a manner that disrupts the process of court. Yeah.
Okay, finally, let's talk about what now, what is the fate of a person who has been convicted, like Aaron Kiza, in such a manner, under such a circumstances. What is his fate?
His fate, he has a number of remedies to pursue. For example, he can choose to appeal against the decision, the conviction and the sentence. He can also decide to, because the appeal would have grounds, for example, of severity and being convicted and heard, that the denial of the right of a fair hearing, that one, those can be some of the grounds. Then he can decide to go for judicial review and challenge the process that reached at his conviction. Because he was not charged one, he was not given an opportunity to defend himself. He was only given a ruling which resulted into conviction and then sentence. So he has a number of avenues to do, and then he can be released unconditionally basing on those issues. And plus, including the manner that he was arrested, he was abducted in. That is a matter of abduction, inhuman treatment, degrading treatment, torture.
Does abduction happen in broad daylight and within court precincts of court?
You saw abduction, because an arrest, if it was an arrest, the constitution is clear, and even all other laws are clear on how an arrest happens. Someone comes, identifies himself or herself, and he says, I am called Kato, I am from UPDF, I am here to arrest you for A, B, C, D. They even tell you why. But the other issue of coming and grabbing you and pulling you and slapping you and kicking you and punching, that's an abduction that we have always been telling people. And it happened in broad daylight. Cameras were capturing it live. So those who have not had the chance, or unfortunately or unluckily experienced or had somebody being kidnapped, what happened to Council Aaron Kiza is a simple abduction.
So he still has avenues to
he can also challenge that kind of thing under human rights.
Anywhere.
Yeah, under Human Rights Enforcement Act in a civilian court, the High Court, to enforce his right. One, a fair hearing. Two, an abduction that happened to him and the violation of his rights to liberty, freedom from torture, inhuman and degrading treatment. All those are avenues. And once the court finds that surely what happened violated the rights of Aaron, he will be released unconditionally, or that what happened as a conviction and a sentence unlawfully, illegally, and therefore now
the ruling can
will
be
just be quashed, and Aaron will be a free man. Then he can.
Finally, from me, is there any or under any circumstances where a person in the dock who is pleading on another offense can also be charged with contempt of court? For instance, he does presents him or herself in a way that is in contempt of court while he is in the dock.
Yeah, surely. Surely. As long as his behavior, his conduct, his actions disrupt the proceedings of court, a judicial officer can charge them in contempt.
So the charge sheet can be amended?
No, it cannot be amended. It will be a different charge. And they will read for you the charge of contempt and told you what you have done. And such actions amount to contempt of court. Then they will say, how do you plead? Can you defend yourself on this offense? Then you defend. If it is unreasonable, then they can charge you for contempt.
So courtrooms must be respected.
Yeah.
Courtrooms must be sanctified in a way that that everyone must present him or herself in a very humble manner.
That's true. That's why they are called temples of justice. Like we go to church and humble ourselves, that's the same way we must humble ourselves and respect ourselves while attending court sessions. It is not only limited to the people in the dock, but even the audience here, the people that have come to follow up cases. Contempt can just hold you anywhere you are.
You've heard from Kato Tumsime, a lawyer, but also someone who has witnessed these things happen, and now you know that contempt of court can hold you anytime you are in courts of law, in the courtroom or outside the courtroom.
In courtroom, contempt. In courtroom.
My name is Prince Apollo. That's it from me. Thank you so much, Kato, for that insightful discussion on a serious offense of contempt of court. I hope our audience now knows what it means, and they know now how to avoid being caught up in such a circumstances. Well, from here, we'll be going into a Misinji with Pastor Aloza Subujingo, but after that, we'll be connecting live with Canaan Land, where there is a power packed overnight. You don't need to miss it. If you're still home, you can prepare and be part of that overnight. Well, let's catch up again next Friday in another edition of the Limelight. Thank you so much for being a good audience. Thank you, Kato.
Thank you so much, Apollo, for hosting me.
I think I'm safe now. I know I want to be caught up in the offense of contempt.
Yeah, sure. And
court.
When you are caught up, you can you have the right to actually be represented by a lawyer of your choice in that offense. So don't deal away with your right to legal representation.
Good evening to you. God bless you, and God bless Uganda.